Order. We continue line by line scrutiny of the crime and policing bill. Before we begin, I have a few preliminary reminders. Committee, I'm sure you're aware of these. Please switch off electronic devices to vibrate silent. No food or drinks are permitted during sittings of this committee except for water, unless you have a particular health need. Obviously, speak to me and I'm sure that'll be fine. Hansard colleagues would be grateful for members could email the speaking notes to hansardnotes@parliament.uk. Alternatively, pass on their written speaking notes to the Hansard colleague in the room. Members are reminded to Bob, very important, to rise from the chair, Bob, and catch my eye if they wish to speak in any debate. So good afternoon to everybody. Just to say that we will have a 2-minute silence at midday, so be aware of that too. So I might need to intervene with an order halfway through a sentence. Let's see. We now come to Government New Clause 21, which has already been debated. Minister, to move formally.
Move formally, sir.
Terrorism offences accepted from defence for slavery or trafficking victims.
The question is that New Clause 21 be read a second time. Does any of that opinion say aye?
Aye.
Contrary, no. I think the ayes have it. The ayes have it. The question is that New Clause 21 be added to the bill. Does any of that opinion say aye?
Aye.
Contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 61, which has already been debated. Minister, to move formally.
Move formally.
Notification requirements.
The question is that New Clause 61 be read a second time. As many of that opinion say aye?
Aye.
Contrary, no. I think the ayes have it. The ayes have it. The question is that New Clause 61 be added to the bill. As many of that opinion say aye?
Aye.
Contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 62, which has already been debated. Minister, to move formally.
Electronic monitoring of compliance with Order England and Wales.
The question is that New Clause 62 be read a second time. As many of that opinion say aye?
Aye.
Contrary, no. I think the ayes have it. The ayes have it. The question is that New Clause 62 be added to the bill. As many of that opinion say aye?
Aye.
Contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 63, which has already been debated. Minister, to move formally.
Move formally.
Conditions for imposing electronic monitoring requirements in England and Wales.
The question is that New Clause 63 be read a second time. As many of that opinion say aye?
Aye.
Contrary, no. I think the ayes have it. The ayes have it. The question is that New Clause 63 be added to the bill. As many of that opinion say aye?
Aye.
Contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 64, which has already been debated. Minister, to move formally.
Move formally.
Data from electronic monitoring in England and Wales Code of Practice.
The question is that New Clause 64 be read a second time. As many of that opinion say aye?
Aye.
Contrary, no. I think the ayes have it. The ayes have it. The question is that New Clause 64 be added to the bill. As many of that opinion say aye?
Aye.
Contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 65, which has already been debated. Minister, to move formally.
Move formally.
Reviews of operation of this chapter.
The question is that New Clause 65 be read a second time. As many of that opinion say aye?
Aye.
Contrary, no. I think the ayes have it. The ayes have it. The question is that New Clause 65 be added to the bill. As many of that opinion say aye?
Aye.
Contrary, no. I think the ayes have it. The ayes have it. Right. We now come to Government New Clause 66, with which it will be convenient to consider Government New Clauses 67 to 86, Government New Clause Schedule 1, and Government Amendments 80 and 81. I call the Minister.
Thank you, Mr. Pritchard, and it's nice to see you back in the chair this morning. This group of clauses makes extensive and timely changes to the law around the sale and marketing of offensive weapons, particularly knives and crossbows. These measures form part of the steps that we are taking to tackle knife crime. They will implement recommendations from the police's independent end-to-end review on online knife sales undertaken by Commander Stephen Clayman at the request of the Home Secretary, and deliver on our manifesto commitment to hold to account senior managers who flout the rules on online sales. So first of all, new clauses 66 and 67 introduce new, stricter age verification for knives bought online at both the point of sale and delivery. New clauses 69 and 70 make the same changes in respect of crossbows. Commander Clayman's review highlighted that existing age verification methods for online sales are insufficient. Buyers can provide false birth dates and parcels can be left with neighbours so that there is no age check of the buyer. Existing legislation, as contained in the Criminal Justice Act 1988 and the Offensive Weapons Act 2019, already requires age checks for the sale and delivery of knives. So we are introducing two key changes to these existing requirements. First, the checks at the point of sale will have to include photographic identity documents, plus a current photograph to demonstrate that the identity documents belong to the buyer. Second, on delivery, couriers will be required to check photographic identification provided by the person receiving the package, and there will be a new offence of handing the knife to someone other than the buyer. This will mean that knives can't be left on doorsteps or with neighbours with no checks of the intended recipient.
Will my honourable friend give way?
Yes, very happy to.
I do thank my honourable friend for giving way, and she will remember me mentioning our local campaigner Julie Taylor, who has campaigned after the death of her grandson Liam on this cause, and she has looked at these new clauses and welcomes them. She actually said to me, anything that helps get rid of this awful crime, she welcomes, and she thanks the government for this. So does she agree with me that this gives an even greater level of protection and prevention to really start to drive down this awful offence of knife crime?
Minister.
Well, I'm very grateful to my honourable friend for that contribution, and it is heartening to know that Julie supports these clauses and recognises the important role that they can play in tackling knife crime. And again, I want to extend my condolences to Julie and the family for the death of Liam. But it's absolutely right that these clauses also have the support of the coalition fighting for tackling knife crime, who have many families, campaigners and victims as well of knife crime, who are helping the government to develop policy and to make sure that we are held to account for what we've promised we will do in terms of halving knife crime over the course of the next decade. So these clauses strengthen the requirements, and the aim is to ensure that under 18s cannot easily evade checks when buying knives online, as they have sadly in the past. So like knives, crossbows are an age-restricted item, and they cannot be sold or hired to anyone under the age of 18. Legislation for crossbows was brought in through the Crossbows Act 1987. In contrast to knives, there has been very little change to that legislation since that date in 1987. So these new clauses seek to introduce the same age verification requirements for the online sale, hire and delivery of crossbows as is being brought in or is already in place for knives. So new clause 69 amends the Crossbows Act 1987 to introduce equivalent age verification methods for crossbows as those in section 141B of the Criminal Justice Act 1988, which provides limitations to the defence which provides limitations to the defence to the offence of selling a knife. For crossbows, where the seller or seller's agent is not in the presence of the buyer, the seller will not be regarded as having taken all reasonable precautions and exercised all due diligence unless all the conditions are met. And these are: condition 1, the seller obtained a copy of an identity document and a photograph of the buyer. Condition 2, the package containing the article was clearly marked by the seller that it contained a crossbow or crossbow parts, and it should only be delivered into the hands of a person aged 18 or over. Condition 3, that the seller took all reasonable precautions and exercised all due diligence to ensure that it would be delivered into the hands of the buyer. And condition 4, the seller did not deliver the package or arrange for its delivery to a locker. Now, as with bladed articles, before dispatch of the crossbow or part of a crossbow, the seller must receive from the buyer a copy of an identity document issued to the buyer and a photograph of the buyer, and confirm that they are aged 18 or over. New clause 70 amends the Crossbow Act 1987 to create a new offence on the part of the seller if they deliver or arrange for delivery to residential premises in respect of the sale or letting of a crossbow or part of a crossbow, similar with equivalent defences to those in section 39A of the Offences Weapons Act 2019 for knives. Yes, of course.
Joe Robertson.
I thank the Minister for giving way, and I thank her for setting out in detail those provisions where crossbows are sold when the seller is not in the presence of the buyer. Just thinking of the wording she used around providing identity documents, photographic evidence, does she see any concern that the wording might be a bit vague and that there is scope for providing false documents? Perhaps you could give some reassurance. In some cases you would have certified copies, so certified by a solicitor or someone of sufficient standing in the community, whatever the wording is. I'm just slightly concerned that false documents could be provided, but perhaps there is provision there to stop that happening.
Well, I'm grateful to the honourable gentleman for that particular point, and of course that is of concern, and it's of concern to me as the Minister. We're obviously introducing this new process and procedure because we think at the moment the current legislation, the current law around deliveries and buying and then the delivery isn't strong enough. But I take that point and I'm going to reflect on it actually. It may be, and I do need to think about this, it may be too onerous to have, as the honourable gentleman was referring to, certified copies. But it's something I will reflect on and return to, I think, because we obviously want to get this right and we want to make sure that accurate documents, legal documents are used. So I will come back to that particular point. So I just wanted to carry on going through these clauses just so we're all very clear about what they're actually going to do. So new clause 70 also provides for a new offence on the part of the courier or the person delivering on their behalf, equivalent to the new offence that I've described for the delivery of a knife. And the courier or person delivering on behalf of the courier must only provide crossbow or parts of crossbows into the hands of the actual buyer and only at the address the buyer provided at the outset. So if the courier or person delivering on behalf of the courier fails to do this, they will commit a summary offence attracting a maximum penalty of an unlimited fine. It will, however, be a defence for a courier or person delivering on behalf of the courier to show that they have checked an official identity document and that the ID has the name of the person indicated by the seller. It shows that the holder is over 18 and that as far as they can tell, the picture in the identity document is of the person at the doorstep. So where businesses who hire out or let crossbows, which for corporate events or entertainment, something that I didn't know actually happened, but apparently it does, and they do so online, then these age verification measures will also apply to both the hire and the delivery of the crossbows, where the hirer is an individual. And finally, new clause 71 also provides a power for the Secretary of State to issue statutory guidance on the new offence under the Crossbows Act 1987. So, turning to the reportable sale of knives, new clause 68 introduces a requirement to report bulk sales of knives where these are made remotely, including online sales. And this will help the police tackle what's called the grey market, the resale of knives on social media. The police tell us that grey market sellers act irresponsibly. For example, they promote knives as weapons, which is unlawful, and they do not conduct age verification checks. So this new clause will give the police information that will enable them to act. Sellers who do not comply with this will be liable to a fine. So sales will be reportable where 6 knives or more, or 2 or more qualifying sets of knives, such as a block of knives, or 1 or more qualifying sets together with 5 or more knives are sold remotely in one sale to be delivered to the same residential address in England and Wales. The reporting requirement is also triggered when multiple sales meeting these limits are made to the same person or residential address in England and Wales within a 30-day period. Genuine business-to-business transactions will be exempt. Businesses will be able to affirm that the purchase is business-related and provide their VAT or company registration number to demonstrate that. Knives which do not have a sharp point, such as cutlery knives, will be exempt. Razor blades and pocket knives with blades of 3 inches or less are already exempt from rules restricting the sale of bladed articles, and they will be exempt from reporting requirements. There will be a partial exemption for qualifying sets of knives, such as kitchen knife blocks. These will be defined as sets of at least 3 knives that are of different size or shape to each other. Only a second purchase of a qualifying set will result in a reportable sale, no matter how many knives it contains. We do not expect the police to act on every report that is made, but what we do expect is for them to act where the purchase is linked to other existing intelligence, for example, evidence of gang affiliation or previous knife crime offences.
Will the Minister give way?
Yes, happy to, yeah.
I thank the Minister for giving way. Is there a risk? I mean, I welcome the new clauses, and by thinking back to my policing days, extremely welcome. Is there a risk, do you think, that if we don't add these clauses, that the potential for knife crime and crossbow crime to actually go higher over the coming years and increase is going to be more prevalent than restricting the crimes itself?
Well, I'm grateful for that question from my honourable friend. And of course, these clauses that we're bringing forward around bulk and suspicious sales came directly from the police, from Commander Clayman and the report that he produced, and his concern around the area of the grey market. So I think it's quite clear that the police believe that this will be necessary for them to use this intelligence to help tackle the problems we've got with knife crime, and obviously that fits with the government's manifesto commitment to halve knife crime over the course of the next 10 years. So the way that this information and this intelligence will be used is it will be sent to a central unit in the first instance, and we will be providing guidance to the police on the use of that information. We expect that information that is not linked to other relevant intelligence linking it to criminality will be deleted and not subject to further investigation. If I turn now to sanctions on online executives, Government New Clauses 72 to 86 and New Schedule 1 introduces civil penalties for online companies. I think it's Schedule, just want to check that's right, yes, it's Schedule 1. Introduce civil penalties for online companies and their senior managers should they fail to take down illegal knife and defensive weapons content when notified of it by the police. So knives and weapons illegally marketed to encourage violence or promote their suitability for use in violent attacks are commonly sold online and used then in senseless attacks. And we know that the boys who murdered Ronan Kander did so using weapons illegally sold online. Many of these knives are marketed on social media and other platforms, meaning these companies indirectly profit off their sale. Commander Clayman's review set out the extent of the problem related to online knife and offensive weapons sales, particularly where it relates to knives being illegally available to young people. The report recommends that social media platforms be required to remove such prohibited material within 48 hours of police notification. These new clauses deliver on this recommendation. Now, the Home Office consulted widely on these measures. We engaged directly with tech companies and held a public consultation. Tech companies and associations, charities, councils and members of the public responded to this consultation, and our response to that has recently been published. Collectively, these new clauses will grant the police now the power to issue content removal notices to online marketplace, social media platforms and search engines. These notices will require them to take down specified illegal content, relating to knives or offensive weapons. If the specified content is not taken down within 48 hours, the company and an executive designated as their content manager would be respectively liable to civil penalty notices of up to £60,000 and £10,000. Additionally, should a company fail to designate an appropriate UK-based executive when required to do so by the police, it would be liable for a civil penalty notice of up to £60,000. So these measures provide important safeguards. Both online companies and their designated executives will have the opportunity to request the content removal notice be reviewed. The police must comply with such requests. Should online companies not have an executive who meets the criteria to be designated as their content manager, they will have the opportunity to inform the police as such. And prior to the issuing of a civil penalty notice, both the company and content manager will have the opportunity to make representations to the police. Finally, penalty notices may of course be challenged in the courts. So I fully expect online companies to act responsibly and take down harmful illegal content when made aware of it. These measures will be used in the rare cases where reckless companies choose to continue hosting such content. So taken together, this is a comprehensive package of measures which will further help restrict the supply of weapons, particularly to children, and help keep our communities safe. And I commend these new clauses to the committee and I beg to move.
Remote sale of knives, etc.
The question is that new clause 66 be read a second time. Shadow Minister.
Thank you, Mr Pritchard. It is a pleasure to serve under your chairmanship. The opposition welcomes some of the measures set out in this grouping which aim to restrict the sale of knives in the wider bid to tackle knife crime. The unregulated purchase of dangerous items such as knives or indeed crossbows presents a serious and growing threat to public safety. Without proper controls, these weapons can be easily acquired by individuals with harmful intent, including gang members, violent offenders and young people at risk of exploitation. The availability of such items online without age verification, purchase limits or traceability undermines efforts to reduce knife crime and protect communities. It also places law enforcement in a reactive position, forced to respond to violence that could have been prevented through stronger regulation and control. Ensuring proper safeguards around the sale and distribution of knives is not about restricting legitimate use, it's about closing loopholes that are currently exploited to devastating effect. Government New Clause 66 strengthens the legal framework around remote sales of knives by tightening the requirement for verifying the age of the buyer. Under the proposed changes to Section 141B of the Criminal Justice Act 1988, sellers must obtain both a copy of a valid identity document and a photograph of the buyer before the sale is made. A reasonable person would need to be satisfied that the buyer is 18 or over based on the evidence. By increasing the burden of proof on the seller and clarifying acceptable forms of ID, this measure aims to reduce the availability of knives to young people and close key loopholes in online transactions, contributing to broader efforts to curb knife crime. Government New Clause 68 introduces a legal duty for sellers in England and Wales to report bulk remote sales of knives and other bladed articles, marking a significant step forward in tackling the online flow of potentially dangerous weapons. The measure is aimed at identifying suspicious buying patterns that may indicate stockpiling for criminal use or illicit resale, helping enforcement bodies to monitor and disrupt supply chains. Notably, the duty applies to individuals and businesses unless the buyer can prove that they're a VAT-registered business or incorporated company. Failure to report such sales will rightly be a criminal offence, though sellers will have a due diligence defence if they can demonstrate they took reasonable steps to comply. This clause bolsters the UK's strategy to reduce knife crime by increasing accountability in the remote sales sector and closing gaps that criminals may exploit. Government New Clauses 69 to 71 amend the Crossbows Act 1987 to tighten remote sale and delivery of crossbows, preventing sales to under 18s. Government New Clause 69 requires sellers to verify the buyer's age, with identity documents and photographs, ensuring marked packages are delivered only to the buyer, not lockers, whilst Government New Clause 70 creates offences for delivering crossbows to residential premises or lockers. Government New Clause 71 defines terms, allows regulations for additional defences and extends guidance to cover crossbow offences. These align with the Bill's aims to enhance public safety. I'd be grateful if the Minister can tell the committee how the government will support businesses in complying with the new verification requirements, what resources will ensure effective enforcement of delivery restrictions. Government New Clause 72 to 83 establish a framework for regulating online service providers by requiring the appointment of content managers to oversee compliance with a new chapter of the bill. Government New Clause 73 mandates the Secretary of State to designate a coordinating officer from a police force or national crime agency to manage functions with authority to delegate tasks. Government New Clause 74 empowers the coordinating officer to issue an appointment notice requiring service providers to appoint a UK resident content manager within 7 days or confirm no suitable candidate exists, providing contact details. Government New Clause 75 requires providers to appoint a content manager within 7 days if a suitable candidate emerges within 2 years after reporting non-existed. Government New Clause 76 allows providers to replace content managers and mandates notification within 7 days if a manager no longer meets eligibility criteria, requiring a new appointment or confirmation of no candidate. Government New Clause 77 obliges providers to notify the coordinating officer of changes in required information within 7 days, and Government New Clause 78 authorises penalties up to £60,000 for non-compliance, including failure to appoint a manager, provide accurate information or correct any false statements. Government New Clause 80 empowers authorised officers to issue content removal notices to providers and content managers, requiring removal of unlawful weapons content within 48 hours. Government New Clause 81 allows recipients to request a review of removal notices within 48 hours, with a senior officer reviewing and confirming, modifying or withdrawing the notice. Government New Clause 82 requires decision notices post-review to enforce content removal within 24 hours or the remaining 48-hour period. I'd like to ask the Minister if the Government will do anything to support service providers, especially smaller platforms, in meeting content manager appointment requirements and in ensuring that there is appropriate guidance or training available. How will the coordinating officer ensure consistent enforcement of these obligations across diverse online services?
Minister.
Can I thank the general tone of the response from the opposition in terms of this group of new clauses that we're bringing forward that come directly from the review that Commander Clayman set out, and also from the manifesto commitment that we made, particularly around the tech executives and holding them to account. Can I say that there has been a great deal of consultation, particularly around the tech executives and how that would work and the engagement with tech companies. I take the Shadow Minister's point about smaller platforms, but can I just say that there has been that engagement. And as to the issue around training and the enforcement in terms of the group of new clauses in relation to the sale and delivery, it's quite clear that these new legal requirements are ones that all courier companies and delivery companies will have to ensure that their staff are trained on, and that there is a defence, just to be clear, that if the person who's delivering the package has taken all steps to make sure that the information that's being provided, the identification document, if they've checked that and they are acting reasonably, that is a defence. But what I'm trying to get at is there will be a need for training and for people to know what their legal obligations are, particularly when they are delivering, because we know that's been a particular issue. And I just want to say as well that the engagement, as I talked about, particularly with the tech executives, has also happened with courier firms and delivery businesses, and will continue. And just so everybody is clear as well, and just going back to the point that the honourable gentleman for the Isle of Wight East raised about these identity checks.
Order. Order. We now stand for the national 2-minute silence to commemorate VE Day. Order. Order. Honourable Minister.
Thank you, Mr Pritchard. I was just going to say that I wanted to make it clear that the documents that are being talked about in relation to providing identity and proving identity are at the moment passports and driving licences. So I take the point that the Honourable Gentleman raised with me in his intervention, but those are the two documents that will be looked at and provided. Now, I think that we will want to make sure that this is going to work, and in the future there may well be other documents that might need to be added to that list. But just to be clear, it's those two documents, and as I also just said, we would expect that a person who is delivering would look at those documents, and I don't really want to get into how those kind of documents can be forged, because that's obviously an issue that's on the mind of the Honourable Gentleman. But at the moment, those are the two, and we would expect them to be examined by a delivery driver or a courier when the items were delivered. I don't know if the Honourable Gentleman wants to come back on that.
Joe Robson.
Yes, thank you. That's helpful. Clearly, if the buyer has to be present when they present those documents to someone making the delivery, you can understand they're obviously documents are very hard to forge, so I wouldn't be suggesting forgery of those documents. I think it was the possibility, and I may simply be wrong here, of someone else presenting those documents. They're not forgeries, they simply are not the passport or driving licence of the buyer. So if the buyer has to be present at some point, then plainly there's not an issue. I welcome that.
Well, I'm grateful that the Honourable Gentleman is clear, and as we said at the beginning of the process, at the point of sale, there has to be that photographic identity provided as well as the identity document to ensure it matches up. So just to be clear on that as well. And with that, I commend these measures to the committee.
New clause 66 proposed as on the amendment paper. The question is that the clause be read a second time. As many of that opinion say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 66 be added to the bill. As many of that opinion say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 67, which has already been debated. Minister, to move formally.
Formally.
Delivery of knives, etc.
The question is that new clause 67 be read a second time. As many of that opinion say aye. Contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 67 be added to the bill. As many of that opinion say aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 68, which has already been debated. Minister to move formally.
Formally.
Duty to report remote sales of knives, etc. in bulk, England and Wales.
The question is that new clause 68 be read a second time. As many of that opinion say aye. On the contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 68 be added to the bill. As many of that opinion say aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 69, which has already been debated. Minister to move formally.
Formally.
Remote sale and letting of crossbows.
The question is that new clause 69 be read a second time. As many of that opinion say aye. Contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 69 be added to the bill. As many of that opinion say aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 70, which has already been debated. Minister to move formally.
Formally.
Delivery of crossbows.
The question is that new clause 70 be read a second time. As many of that opinion say aye. Contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 70 be added to the bill. As many of that opinion say aye. Contrary, no. The ayes have it. The ayes have it. We now come to Government New Clause 71, which has already been debated. Minister to move formally.
Formally.
Sale and delivery of crossbows supplementary provision.
The question is that new clause 71 be read a second time. As many of that opinion say aye. Contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 71 be added to the bill. As many of that opinion say aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 72, which has already been debated. Minister to move formally.
Formally.
Relevant user-to-user services, relevant search services and service providers.
The question is that new clause 72 be read a second time. As many of that opinion say aye. Contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 72 be added to the bill. As many of that opinion say aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 73, which has already been debated. Minister to move formally.
Formally.
Coordinating officer.
The question is that new clause 73 be read a second time. As many of that opinion say aye. Contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 73 be added to the bill. As many of that opinion say aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 74, which has already been debated. Minister to move formally.
Formally.
Notice requiring appointment of content manager.
The question is that new clause 74 be read a second time. As many of that opinion say aye. Contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 74 be added to the bill. As many of that opinion say aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 75, which has already been debated. Minister to move formally.
Formally.
Appointment of content manager following change of circumstances.
The question is that new clause 75 be read a second time. As many of that opinion say aye. Contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 75 be added to the bill. As many of that opinion say aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to Government News Clause 76, which has already been debated. Minister to move formally.
Formally.
Replacement of content manager.
The question is that new clause 76 be read a second time. As many of that opinion say aye. No. I think the ayes have it. The ayes have it. The question is that new clause 76 be added to the bill. As many of that opinion say aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 77, which has already been debated. Minister to move formally.
Formally.
Duty to notify changes in required information.
The question is that new clause 77 be read a second time. As many of that opinion say aye. Contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 77 be added to the bill. As many of that opinion say aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 78, which has already been debated. Minister to move formally.
Formally.
Failure to comply with content manager requirements, civil penalty.
The question is that new clause 78 be read a second time. As many of that opinion say aye. The contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 78 be added to the bill. As many of that opinion say aye. The contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 79, which has already been debated. Minister to move formally.
Formally.
Unlawful weapons content.
The question is that new clause 79 be read a second time. As many as that opinion say aye. The contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 79 be added to the bill. As many of that opinion say aye. The contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 80, which has already been debated. Minister to move formally.
Formally.
Consent removal notices.
The question is that new clause 80 be read a second time. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 80 be added to the bill. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. We now come to government new clause 81, which has already been debated. Minister to move formally.
Formally.
Consent removal notices reviewed.
The question is that new clause 81 be read a second time. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 81 be added to the bill. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. We now come to government new clause 82, which has already been debated. Minister to move formally.
Formally.
Decision notices requiring removal of unlawful weapons content.
The question is that new clause 82 be read a second time. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 82 be added to the bill. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. We now come to government new clause 83, which has already been debated. Minister to move formally.
Formally.
Failure to comply with consent removal notice or decision notice civil penalties.
The question is that new clause 83 be read a second time. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 83 be added to the bill. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. We now come to government new clause 84, which has already been debated. Minister to move formally.
Guidance.
Question is that new clause 84 be read a second time. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 84 be added to the bill. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. We now come to government new clause 85, which has already been debated. Minister to move formally.
Notices.
The question is that new clause 85 be read a second time. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 85 be added to the bill. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. We now come to government new clause 86, which has already been debated. Minister to move formally.
Formally.
Interpretation of chapter.
The question is that new clause 86 be read a second time. As many of that opinion say aye.
Aye.
On the contrary, no. No? Yes, right. I think the ayes have it. I think the ayes have it. The question is that new clause 86 be added to the bill. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. We now come to government new clause 87, with which it will be convenient to consider government amendment 82. And I call the minister.
Thank you, Mr. Pritchard. It is a pleasure to serve you in the chair this afternoon. Mr. Pritchard, no pedestrian or other road user should ever feel unsafe. Their safety is a priority for this government, and I know such sentiments will be shared across the House. Like all other road users, cyclists are required to comply with road traffic law in the interests of the safety of other road users. This is reflected in the Highway Code. There are already existing offences within the Road Traffic Act 1988 to prohibit dangerous and careless cycling. These offences carry a maximum penalty of £2,500 and a £1,000 fine, respectively. In rare, tragic cases that have occurred in recent years where there has been a death or serious injury caused by a cyclist, the drawbacks of relying on the current offences, notably the Offences Against the Person Act 1861, have been clear. Unlike the penalties available for motoring offences that have the same tragic outcome, this offence carries a maximum penalty of 2 years' imprisonment. The Government does not believe that these current penalties are appropriate in cases where a cyclist's behaviour is dangerous or careless and results in the death or serious injury of another person. Therefore, new clause 87 introduces new offences of causing death or serious injury by dangerous or careless cycling, making our streets safer for pedestrians and other road users. Those causing death by dangerous cycling or careless cycling will face a maximum penalty of life imprisonment or 5 years imprisonment, respectively. Those who cause serious injury will face a maximum penalty of 5 years imprisonment or 2 years imprisonment, respectively. Government Amendment 82 extends these new offences to England, Wales and Scotland. These penalties ensure that there is parity across the existing framework of motoring-related offences. All road users, whether they are drivers or cyclists, whose behaviour results in the death or serious injury of another road user, will face the same penalties. To be clear, it is not our intention to discourage cycling. It is one of this government's broader objectives to promote cycling for its health, economic and environmental benefits. However, While the majority of cyclists are responsible and cycle safely, there are rare instances where victims have been seriously or fatally injured by irresponsible and dangerous cyclist behaviour. As a result, these offences will ensure that people who cause serious or fatal harm because of their reckless cycling behaviour are subject to appropriate punishment. Finally, before moving these amendments, I would like to pay personal tribute to the Right Honourable Member for Chingford and Woodford Green and to Matthew Briggs, who have tirelessly campaigned for these changes to be made. I personally had the privilege of meeting Matthew Briggs and discussed the need to have this new offence in place and how the devastating impact of the death of his wife Kim in 2016 by a reckless cyclist has pushed and shown the need to create these new offences. And for that reason, Mr Pritchard, I commend these amendments to the committee.
Dangerous, careless or inconsiderate cycling.
The question is that new clause 87 be read a second time. Shadow Minister.
The devastating consequences of road traffic collisions caused by reckless or dangerous behaviour are not limited to motor vehicles. In recent years, a small but significant number of cases have emerged where pedestrians and other vulnerable road users have been seriously injured or even killed as a result of dangerous or careless cycling. This new clause rightly recognises that while the majority of cyclists are law-abiding and responsible, the law must be equipped to deal appropriately with the minority who behave recklessly and put others at grave risk. Currently, there's a glaring gap in the legal framework. While motorists who cause death or serious injury through dangerous or careless driving face severe legal consequences, no equivalent provision exists for cyclists. This clause introduces parity in accountability, ensuring that victims and their families are not left feeling that justice is denied simply because the vehicle involved was a bicycle rather than a car. New Clause 87, alongside Government Amendment 82, ensures that the legal definitions of dangerous and careless cycling reflect the realities of modern shared road and path usage, including in public places beyond traditional roadways. With the increase in cycling on footpaths, shared spaces and pedestrianised zones, it's vital that the law keeps pace and applies wherever the public might be put at risk. Importantly, the introduction of these offences does not criminalise cycling itself. It targets only those rare but serious cases where a cyclist's conduct falls far below that would be expected of competent and considerate road users. It draws on the well-established legal test from dangerous and careless driving legislation, helping ensure that the proposed offences are proportionate, fair and clearly understood. As members will be aware, the member for Chingford and Woodford Green has long campaigned for a change to the law regarding responsible cycling, and I pay tribute to his work to deliver this improvement to public safety. The last government confirmed that it would adopt an amendment to the Criminal Justice Bill, which would have resulted in a comparable change to the one we see today. Much of this would not have been possible without the sustained efforts of people such as Matthew Briggs, who in 2016 tragically lost his wife, Kim Briggs, aged just 44, after she was hit by a cyclist riding a fixed-gear bike with no front brakes. She sustained catastrophic head injuries and sadly died a week later. Unfortunately, Kim is just one of many victims, and Matthew one of many families harmed by these situations. But he's campaigned for this change in the law after tragically losing a loved one. I pay tribute to Matt and his campaign for justice and hope that this change effectively bridges the gap in the law that so many have highlighted. Finally, this measure sends a strong message that all road users, regardless of their mode of transport, are responsible for the safety of others. It underlines the seriousness with which Parliament treats the loss of life or serious injuries, promotes responsible cycling and contributes to safer public spaces for everyone.
No questions, Chair. It's great to see the support.
Sure. Okay. New clause 87 proposed as on the amendment paper. The question is that the clause be read a second time. As many that can say aye. Aye. Contrary no. The ayes have it. The ayes have it. The question is that new clause 87 be added to the bill. As many that can say aye. Aye. Contrary no. I think the ayes have it. The ayes have it. So we now come to Government New Clause 88, which it would be convenient to consider Government's New Clauses 89 and 90. I call the Minister Yes, Minister.
New clauses 88 to 90 further update our public order legislation to reflect operational experience, and it is important that the legislation keeps pace with the operational realities faced by the police on the ground. So in the wake of the events in Israel and Gaza on the 7th of October 2023, we've seen a wave of large-scale protests across the United Kingdom. While, of course, the right to protest is a cornerstone of our democracy and the majority of demonstrations have been peaceful, we cannot ignore the very real impact some of these gatherings have had on religious communities. We've heard troubling reports of people feeling too intimidated to attend places of worship of all faiths and of services being cancelled due to the proximity and nature of these protests. Therefore, New Clause 88 seeks to provide better protection to religious communities from intimidation caused by protests within the vicinity of their place of worship. The police do have existing powers under the Public Order Act 1986 to manage protests where there is a serious disruption to the life of the community or intentional intimidation. However, these powers often do not capture the types of harm currently being experienced by religious communities, especially where the intimidation is not deliberate but nonetheless very real for those affected. The intention of this new clause is to strengthen the police's powers to manage intimidatory public processions, public assemblies, or one-person protests near places of worship, specifically by allowing police to impose conditions where they reasonably believe that the procession, assembly or protest may result in the intimidation of and deter those seeking to access places of worship. New Clause 88 achieves this by creating a new threshold within sections 12, 14 and 14ZA of the 1986 Act, under which the police can impose conditions on public processions, public assemblies and on one-person protests. So to be clear, it does not ban protests outright, but enables the police to use this threshold to consider the appropriate times, locations or routing a protest should have to avoid intimidating those wishing to practice their faith at their place of worship. This new clause will allow the police to assess whether a protest may create an intimidating atmosphere that could deter people from accessing places of worship to carry out religious activity or conducting religious activities there, regardless of whether the organisers of the protest themselves intended for the protest to have that effect. Turning now to New Clause 89, in managing recent protests, the police have relied on their powers under sections 12 and 14 of the Public Order Act 1986 to impose those conditions, for example, where there is a risk of serious public disorder or serious disruption to the life of the community. However, under the current law, only the most senior officers physically at the scene can impose these conditions on live protests or where people are assembling with a view to take part. So this can cause delays, particularly when strategic or tactical commanders, known as the gold and silver commanders, who are often based in off-site control rooms but have better access to intelligence but are unable to impose conditions directly. This can also lead to inconsistencies in how similar protests are managed across different locations, especially when multiple events occur at once. Policing stakeholders have made clear that allowing gold and silver commanders to impose conditions remotely where the statutory thresholds are met would improve the timelines, consistency and effectiveness of public order policing. These commanders typically have the best oversight of unfolding events and are well placed to make informed decisions. New Clause 89 therefore amends the Public Order Act 1986 to enable gold and silver commanders to exercise powers to impose conditions under sections 12(1) and 14(1) in relation to public processions and assemblies. Finally, New Clause 90 addresses two operational issues raised by the Department for Transport and the Ministry of Defence to ensure that public order powers can be used effectively by the British Transport Police and the Ministry of Defence Police. First, it amends the definitions in the Public Order Act 1986 to allow the BTP to impose conditions on public assemblies taking place at railway stations. Currently, the law restricts the use of these powers to open-air locations, which limits BTP's ability to manage protests in enclosed but high-risk public spaces like major stations. This change will ensure that BTP can act appropriately within their jurisdiction across England, Wales and Scotland. Second, it corrects a legislative error made in 2004 when which unintentionally prevented BTP from using Section 60AA of the Criminal Justice and Public Order Act 1994, the existing power to require individuals to remove face coverings. This amendment restores that power. It also empowers the MDP to issue authorisations under Section 60AA and 60 to enable MDP officers to exercise powers under these provisions within its jurisdiction in the same way as territorial police forces do. So these are technical but important amendments. They do not expand thresholds or scope of the powers themselves. They simply ensure that BTP and MDP can apply them where appropriate to keep people safe, particularly in transport hubs and around defence infrastructure. The proposals reflect direct feedback from operational policing and will bring clarity and consistency to the use of public order legislation, and I commend these new clauses to the committee and beg to move.
Places of worship, restriction on protests.
Question is that new clause 88 be read a second time. Shadow Minister.
Thank you. New clause 88 rightly seeks to strengthen protections for the freedom of religion and belief by ensuring that individuals are not deterred or intimidated from attending or participating in religious worship due to protests taking place in the vicinity of places of worship. It balances the right to peaceful protest with the fundamental right of individuals to practice their faith without fear or obstruction. Places of worship are not just buildings. They're sanctuaries for reflection, community and faith. When people are intimidated from entering these spaces or carrying out religious observance because of aggressive or targeted protest, it undermines not only their personal freedoms, but the broader principle of religious tolerance. This clause helps ensure that those attending religious services can do so without being subject to harassment or psychological pressure. The provision is not a ban on protest. It enables the police to impose conditions, not prohibitions, on processions, assemblies, and even one-person protests that occur in the vicinity of a place of worship, where such demonstrations risk intimidating individuals of reasonable firmness and deterring them from participating in religious activities. The threshold is carefully defined to target behaviour that causes harm while still protecting legitimate expression of opinion. It's important to recognise that while some may easily dismiss this clause, there are real-world examples of people believing that protests are being used to undermine the ability to worship. For example, recently in Clifton-on-Sea, a protest organised by Action for Palestine, which the Palestinian Solidarity Campaign described as not constructive, took place on Shabbat during the final week of Pesach in a Jewish neighbourhood where many residents would be travelling to and from the synagogue. The local rabbi said there were quite a few people in the community who were so intimidated that they decided to go to their parents in London for the weekend to get away completely. Others decided to attend one of the other Orthodox synagogues in the area, like the Westcliff Haredi Synagogue, and ended up having to walk a mile to make Saturday's 2 services. While I would not expect the Minister to comment on the specifics or on whether this would constitute a breach of the clause in question, it highlights how people practising their religion have felt targeted by particular protests. Given the rise in targeted demonstrations, whether based on religion, race or identity, this clause ensures the law is responsive to the realities of contemporary protest dynamics. It draws on the existing powers under the Public Order Act 1986, applying them specifically in a context where dignity, privacy and religious freedom deserve particular safeguarding. Ultimately, this clause is a proportionate and necessary step to preserve the peaceful coexistence of rights, the right to worship freely and the right to protest responsibly. It affirms that places of worship must remain accessible and free from intimidation for all communities. I'd be grateful if the Minister could answer the following questions. How does the Minister ensure that this clause strikes the right balance between protecting freedom of religion and upholding the right to protest under Articles 9, 10 and 11 of the ECHR? What guidance will be provided to the police to assess whether a protest may intimidate persons of reasonable firmness? How will subjectivity be mitigated to avoid arbitrary enforcement? And has the Home Office identified particular recent incidents that demonstrate a pressing need for this power? How frequently does the Minister expect it to be used? New Clause 89 updates Sections 12 and 14 of the Public Order Act 86 to clarify and broaden the delegation of powers to impose conditions on public processions and assemblies. Currently, such decisions are reserved for a senior officer present at the scene. This clause ensures that in England and Wales, a police officer may also exercise this power if they have been explicitly authorised by a chief officer of police. This amendment strengthens the operational flexibility of the police, particularly in situations where a senior officer is not present on site, but where timely decisions are needed to manage risk, prevent disorder, or ensure public safety. It acknowledges the realities of modern protest management, where rapid deployment and coordinated responses often rely on delegated authority structures rather than fixed hierarchies on the ground. Allowing a chief officer to designate another officer to exercise these powers ensures both accountability and agility. It maintains the principle that such decision must come from a senior level of authority while adapting to operational realities such as spontaneous protests or events that span large geographic areas. The clause does not expand the grounds for imposing conditions, nor does it change the legal thresholds that must be met. It simply ensures that the police can act more responsibly and proportionately when necessary to protect the public, prevent serious disruption and uphold the law. New Clause 90 clarifies and extends the application of certain public order powers to the British Transport Police and the Ministry of Defence Police, ensuring consistency and legal clarity across all policing bodies operating in England and Wales. The changes update definitions in the Public Order Act 86 and the Criminal Justice and Public Order Act 94 to align with the operational jurisdictions of the BTP and MDP. Specifically ensures that their officers can exercise public order powers such as imposing conditions on trespassery assemblies or using stop and search and facial covering removal powers in the locations they are lawfully empowered to police, such as railway property or defence estates. The ability to exercise powers under the 1986 Act and the 94 Act will understandably be welcomed by many parties. In the case of the British Transport Police, we've seen instances in the past 2 years of disruptive assemblies on the estates where they're empowered to police. Additionally, given concerns about attacks on public-facing workers, which we've discussed extensively during these sessions, the ability to use Section 60 powers under the 94 Act should be welcomed. However, has the Government made an assessment of how widely these powers will be used? We've had many discussions in the House about the resources allocated to police forces more broadly. However, both BTP and the MDP will have their own specific constraints. Therefore, it would be useful to know whether any estimate has been made of how widely these powers will be used and whether they're likely to require additional operational resources.
Thank you, Mr. Pritchard, and it's a pleasure to serve under your chairship. I, like my honourable friend, the Minister, will always defend the right to protest, but it must be appropriate. Having your voice heard must not come at the expense of intimidating those who are peacefully worshipping. And like the honourable member for Stockton West, only recently in Southend, my constituents were affected by a march that was purposely routed past a place of worship at the time when people were due to be leaving that place of worship. And we've had similar evidence of that happening across the country. So let's be clear, it's not acceptable that people should be intimidated while they go to or from or while they're in their place of worship, whatever their religion. So I welcome these new clauses. Thank you.
Minister.
Thank you, Mr. Pritchard. And can I just say I'm very grateful for the short speech that my honourable friend just made there. He had spoken to me about the events in Westcliff-on-Sea and the impact it had on that particular community. And I was also grateful for the Minister referencing that particular incident, because I think it sets very clearly why the provision we're bringing forward in this new clause is necessary. So I welcome that. In terms of the question that the Shadow Minister raised with me about whether we are going to sort of stop legitimate protests and somehow put the right to religious worship above the right to protest, I just want again to make this really clear. This amendment does not place the freedom of religion above the right to protest. I think we all agree that the right to protest is a very important part of our democracy. But what it does do is seek to balance both the rights by ensuring protesters do not unduly intimidate or prevent individuals from accessing places of worship. And so while the right to protest remains key and fundamental, these provisions in this new clause clarify police powers to manage those protests near places of worship, ensuring that the freedom of religion is protected without imposing a blanket restriction on demonstrations. So the intent is not to curtail protest rights, but to prevent situations where protests create a hostile environment that discourages religious observance, applying equally, and I think this is important to know, equally to all faiths. This is all places of worship, and not just as we started off talking about, but a specific religious group. It applies to all places of worship. And in terms of resource implications, which the Shadow Minister raised for BTP and MDP, and obviously the requests to bring forward these provisions were because of the operational needs of those police forces, and I'm expecting that they will be able to deal with any costs arising from New Clause 90 from the existing budget that they hold. And as to training, the Shadow Minister also raised the issue about training and making sure that police officers understood the new introduction of these provisions. Can I just say to the Shadow Minister, and I'm sure he probably agrees with me on this, there is extensive training that goes on of police officers, and I think particularly around public order, we know that there is a very well worn path of how you train officers at the right level, depending on the situation. And I recently had the pleasure of meeting officers down at Gravesend for the Metropolitan Police, who do a lot of public order work, and to see firsthand that training and the amount of resource that goes in to ensuring those officers are equipped and know the rights that they have and how most effectively to use them. So I think with these new provisions coming in, that will be part of that continuation of the training that goes on for police officers alongside the work that the College of Policing do too. So on that basis, I commend the provisions to the committee.
New clause 88 proposed as on the amendment paper. The question is that the clause be read a second time. As many of that opinion say aye. Aye. Contrary, no. I think the ayes have it. The question is that new clause 88 be added to the bill. As many of that opinion say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 89, which has just been debated. Minister to move formally.
Powers of senior officers to impose conditions on protests.
Questions that new clause 89 be read a second time. As many of that opinion say aye.
Aye.
Contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 89 be added to the bill. As many of that opinion say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 90, which has already been debated. Minister to move formally.
Amendments relating to British Transport Police and Ministry of Defence Police.
The question is that new clause 90 be read a second time. As many of that opinion say aye.
Aye.
Contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 90 be added to the bill. As many of that opinion say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 91, with which it will be convenient to consider Government New Clauses 92, 93, 94, and Government Amendments 83, and I call the Minister.
Thank you, Mr Pritchard. Currently in criminal courts, adult defendants do not have a general right to anonymity, reflecting the principle of open justice. However, judges may impose reporting restrictions where the disclosure of identifying information could hinder the administration of justice or impact fair trial rights. Armed police officers perform a unique and dangerous role. They are trained to use lethal force on behalf of the state to protect the lives of our citizens. Their work requires them to confront situations that demand split-second decisions that can have profound legal and personal ramifications. They respond to major crimes involving high-risk individuals, often linked to organised crime groups. This inherently dangerous role naturally increases the risk of retribution towards both officers and their families, a risk highlighted by the Police Accountability Review. The Government's plan to introduce the measures set out in new clauses 91 to 94 were originally announced to this House by my Right Honourable friend, the Home Secretary, on the 23rd of October. They address specific concerns raised during the Police Accountability Review and following the trial of Sergeant Martin Blake. They will help deliver on our commitment to rebuild the confidence of police officers in their vital work to keep the public safe. New Clause 91 creates a presumption of anonymity for firearm officers who are charged with offences related to the discharge of their weapon during their official duties. This presumption does not extend to other police officers who use force in their duties, nor does it extend to firearms officers if force is used in the line of duty that does not involve discharging a firearm. The starting point for the court will be that anonymity should be granted in these cases, which will remain in place until the defendant is sentenced. New Clause 91 requires that the court must withhold identifying details from the public during proceedings and give a reporting direction. The terms of the reporting direction are set out in New Clause 93 and prevent the publication of any material which may lead to the identification of the defendant. New Clause 91 also gives the courts statutory powers to ensure that the defendant's identity is protected in the courtroom, if it is in the interest of justice to do so. New Clause 94 sets out the types of measures which can be used, such as screens or voice modulation. It will be for the court to decide whether these are required. Judicial discretion is preserved under these new provisions, enabling courts to disclose identifying details or lift reporting restrictions where considered necessary, taking into account the specific circumstances of the case and the overall interests in justice. New Clause 92 provides courts with the statutory authority to extend in-court anonymity measures and reporting restrictions beyond sentencing, should the defendant wish to appeal their conviction. However, this does not establish a presumption, nor does it apply if a firearms officer convicted of an offence seeks only to appeal their sentence. Where a firearms officer is convicted, their right to anonymity ceases at the point of sentencing. However, the court may order that anonymity continues pending the outcome of an appeal. If the conviction is upheld on appeal, the right to anonymity will cease upon the finalisation of that appeal. Conversely, where an officer is exonerated, their right to anonymity will continue, allowing them to resume their professional and personal lives without fear of stigma or threats to their safety. Ensuring national safety and security is a top priority for this government, and the role of firearms officers is essential to achieving this. They serve in this difficult and demanding role voluntarily, and we cannot expect them to perform their duties effectively without providing adequate safeguards to protect them and their families. Amendment 83 provides for these new clauses to come into force 2 months after this bill is passed. I commend these government new clauses and amendment to the committee.
Anonymity for authorised firearms officers charged with qualifying offences.
The question is that new clause 91 be read a second time. Shadow Minister.
Thank you. Government new clauses 91 to 94 provide anonymity protections for authorised firearms officers in legal proceedings involving qualifying offences. Government new clause 91 ensures that officers charged with offences related to their authorised use of lethal weapons discharged in a conventional round have their personal details withheld and reporting directions issued unless contrary to justice, protecting them from public scrutiny and potential threats during sensitive investigations. This fosters officers' confidence in performing high-risk duties as they're shielded from premature exposure before conviction. Secondly, Government New Clause 92 extends these protections to convicted officers pending appeals, allowing courts to maintain anonymity if necessary for justice, which supports fair appeal processes by preventing irreversible reputational damage if convictions are overturned. Thirdly, Government New Clauses 93 and 94 provide clear mechanisms, reporting directions for anonymity orders to enforce these protections while ensuring judges and juries retain access to the officer's identity, balancing transparency with safety. As the Minister has said, members will be all too aware of the case of Sergeant Martin Blake, acquitted in October 24 of murdering Chris Cabba after a 2022 shooting in London. Blake faced death threats, including a £10,000 bounty, forcing him into hiding, highlighting the need for anonymity to protect officers and their families from retribution during trials. These will help ensure officers who act in good faith under dangerous circumstances, recruitment and retention in firearms roles, and public safety are protected from such vindictive attacks whilst the judicial process is underway, whilst also allowing the courts to lift protections when justice demands. I'd ask the Minister to give some further comment on how the Government will ensure courts balance anonymity protections with public interest in transparent justice. In particular, what guidance will be provided to courts to assess when anonymity is contrary to the interests of justice?
Thank you, Chair. I welcome the tone in which the opposition spokesperson has presented his comments and shares our concern about the need for these new measures. It's important to say that judges will, of course, have all relevant information and the need to balance open justice around the need to protect firearms officers in these specific instances. The measures recognise exceptional circumstances of defendants in these cases and creates that presumption of anonymity. That means that that will be the starting point for the court, and that the starting point will be that anonymity should be granted in these cases unless it is contrary to justice to do so. And in terms of open justice and limiting the freedoms of the press as well, I just wanted to add that open justice is, and the ability for the press to report on these cases does continue to be an important process and principle of our justice system, and this legislation will respect those key principles. A court may already order anonymity measures or reporting restrictions in a case where the court judges that a disclosure of a defendant's identity would give rise to a real and immediate risk to life. And this measure is being introduced in recognition of the unique responsibilities, as I've already said, that firearms officers have and the potential risks associated with their identification during court proceedings. So I think it's really important that judges and the courts get the balance right here, but that this measure is absolutely necessary.
New clause 91 proposed as on the amendment paper. The question is that the clause be read a second time. As many of that opinion say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 91 be added to the bill. As many of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 69, which has already been debated. Minister, to move formally.
Beg to move.
Anonymity for authorised firearms officers appealing convictions for qualifying offences.
The question is that new clause 92 be read a second time. As many of that opinion say aye.
Aye.
Contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 92 be added to the bill. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 93, which has already been debated. Minister, to move formally.
Move formally.
Authorised firearms officers reporting directions.
The question is that new clause 93 be read a second time. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 93 be added to the bill. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 94, which has already been debated. Minister, to move formally.
Move formally.
Authorised firearms officers anonymity orders.
The question is that new clause 94 be read a second time. As many of that opinion say aye.
Aye.
Contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 94 be added to the bill. As many of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. Now we now come to new clause 1, with which it will be convenient to consider new clauses 2, 3 and 45. These new clauses were tabled by a member who is not a member of this committee. Does a member of this committee wish to move this clause or any of the clauses in the group? Okay, we'll move on. We'll move right on to, we now come to new clause 4. This new clause was tabled by a member who is not again a member of this committee. Does any member of the committee wish to move this clause? No? We'll move on. We now come to new clause 5, with which it will be convenient to consider new clause 6, 7 and 51. New clause 5 was tabled by a member not on this committee. Any member of the committee wish to move this clause?
Yes.
Shadow Minister.
Thank you. New clause 6 introduces a safeguard to ensure that all individuals featured in pornographic content online are verified as adults. By requiring verification before content is created and before it's published, the clause strengthens protections against the inclusion of minors, whether through coercion, deception or manipulation, and ensures that no content involving underage individuals is ever legally uploaded in the first place. This is a clear and necessary step to combat child sexual exploitation online, and one which aligns with the wider public expectations around safety and decency on digital platforms. I know the Honourable Member for Reigate has raised this issue in the House on multiple occasions, reflecting deep concern over the ease with which harmful and unlawful content can slip through the cracks of unregulated online platforms. This clause takes that concern seriously, placing a firm legal duty on content hosts to verify the age and consent of all individuals involved. It shifts the burden onto platforms where it rightly belongs, to adopt robust age verification measures and uphold basic standards of safety and legality. This clause not only protects children from exploitation, but also helps rebuild public trust in the digital environment by demonstrating that the law is keeping pace with technology. The suggestion from this amendment that pornographic content can be uploaded without the age of individuals involved being verified is very, very disturbing. I'd be grateful if the Minister could comment on this and why she feels this amendment might not be necessary, and what is in place to prevent content featuring minors from being uploaded. The pornography review, led by Baroness Burton, has recommended that individuals who feature in pornography should have the right to withdraw their consent at any time to the continued publication of that content. The review states, even if a performer or creator has provided consent for the initial recording and sharing of pornographic content, they should have every right to withdraw consent at a later point and have that content removed. I'd be keen to hear the view of the Minister, in particular why she thinks this recommendation is wrong. New clause 51 seeks to update section 63 of the Criminal Justice and Immigration Act by expanding the definition of extreme pornographic material to include depictions of non-fatal strangulation, where it constitutes an act of battery and affects a person's ability to breathe. The purpose of this amendment is to reflect growing concern from victims groups, criminal justice professionals and law enforcement about the increasing normalisation and distribution of such harmful content. Depictions of strangulation, even when simulated, have been linked to increased risk of real-world violence, especially against women. It's been suggested that strangulation is a strong predictor of future domestic homicide, and normalising its portrayal in pornography risks reinforcing abusive behaviour. Currently, the law prohibits extreme pornography that portrays serious injury or life-threatening acts. However, non-fatal strangulation, though deeply dangerous and traumatic, is not consistently covered by the existing legal framework. This amendment would close that gap, providing clarity to police and prosecutors and sending a clear message that depictions of life-threatening violence for sexual gratification are unacceptable. By targeting depictions where the act affects a person's ability to breathe and amounts to battery, the clause is narrowly focused to avoid capturing consensual legal adult activity, while still addressing that which represents serious harm. It brings the law into line with recent legislative steps, such as the offence of non-fatal strangulation introduced in the Domestic Abuse Act 2021, acknowledging the real risk and impact of this conduct. Ultimately, this change would strengthen protections for the public and uphold standards of decency, particularly in safeguarding against material that eroticises violence and coercion. To conclude, I do not wish to divide on New Clause 6, but would like to divide on New Clause 51. But understand this will be considered later.
Pornographic content, online harmful content.
The question is that New clause 5 be read a second time. Minister.
Thank you, Chair. I want to make it very clear to honourable members that I have immense sympathy for the sentiments behind all of the amendments in this group. We all in this House wish to make society a safer place for women and girls, and indeed this government was elected with a commitment to halve violence against women and girls. The fight against the proliferation of extreme pornography and access to harmful material is one that I am sure we will believe is one step to achieving that goal. And so, before I respond to New Clause Amendment 5, 6, 7 and 51, I first wanted to share a few thanks. Firstly, to my honourable friend for Lowestoft for tabling New Clause Amendments 5, 6 and 7, and for tirelessly campaigning to raise awareness of online harm. I also want to thank the Honourable Member for Stockton West for tabling New Clause Amendment 51, and importantly to Baroness Burton, whose independent report into pornography provides us with the invaluable insight into pornography and online harm, which the Government continues to consider carefully. All of the amendments shed light on serious issues, and I welcome them being brought to the fore today. New Clause Amendment 5 aims to equalise the treatment of pornography regulation online and offline by making legal but harmful content prohibited online. This amendment is seeking to give effect to a recommendation made by Baroness Burton in her independent pornography review, which makes a case for bringing parity between the regulation of pornography online and offline regulation. Baroness Burton recommends either achieving this through a new pornography code under the Online Safety Act or a publication offence, which would render a variety of currently legal pornography as content as illegal. This is similar to the aims of the amendment proposed in New Clause 5 by my honourable friend. Now, before I respond to the amendment, I will first set out our current legislative framework. Currently, both online and offline pornography are subject to criminal and regulatory legislation and enforcement. The Video Recordings Act 1984 makes it an offence to distribute pornography as physical media formats that has not been classified by the British Board of Film Classification. The BBFC will not classify any content in breach of criminal law and also will not classify certain other types of pornography. Section 368E of the Communications Act 2003 builds on this by prohibiting on-demand programme services such as ITVX or Prime Video from showing prohibited material, which includes any video which has been refused classification certification by the BBFC and any material which would be refused a classification certificate if it were considered by the BBFC. This is enforced by Ofcom as a regulatory matter. In addition, the Online Safety Act 2023 treats certain pornography or related material offences as priority offences under the Act, which means user-to-user services must take proactive measures to remove extreme pornography, intimate image abuse and child sex abuse material from their platforms. The Act also places a duty on user-to-user service providers to take steps to prevent it from appearing online in the first place. These provisions apply to services even if the companies providing them are outside the UK, if they have links to the UK. The criminal law also prohibits possessing extreme pornography or publishing obscene material, either online or offline. The Obscene Publications Act 1959 extends to the publication of obscene material other than pornography. The Video Recordings Act 1984, the Licensing Act 2003, and Section 63 of the Criminal Justice and Immigration Act 2008, which criminalises the simple possession of extreme pornographic images. The amendment tabled by my honourable friend proposes the publication or facilitation of publication of such content online to be made a criminal offence, with regulatory enforcement of this new criminal regime, where the person publishing the content is an online platform on which content is published. The amendment creates a criminal offence which relies on the definition in Section 368E of the Communications Act 2003. This definition requires a judgment to be made about whether the BBFC would classify content which has not been subject to the classification process. Creating this style of criminal offence would require a clearer and more certain definition of this content, as any individual would need to be able to clearly understand what conduct may result in their conviction. Extensive further work would be needed to consider and define what currently legal online pornography cannot be published with sufficient certainty to ensure any offence was enforceable and workable as intended. Turning to New Clause Amendment 6, which similarly attempts to give effect to the recommendations made by Baroness Burton's review of pornography. The amendment seeks to create additional requirements for websites hosting pornographic material to verify that all individuals featured were over 18 before the content was created, consented to the publication of the material, and are able to withdraw that consent at any time. This would further regulate the online pornography sector and create a new criminal offence for individuals who publish or facilitate the publishing of content online where the age and valid consent of the individuals featured have not been verified. The underlying conduct depicted if a person is under 18 or non-consenting would include child sexual abuse, sexual assault, non-consensual intimate image abuse, and potentially modern slavery offences. The existing criminal law prohibits the creation, distribution and possession of child sexual abuse material and the possession of extreme pornographic material, which includes non-consensual penetrative sexual acts. Regarding the distribution of indecent images of children, the law in this area is very clear. Under the Protection of Children Act 1978, the UK has a strict prohibition on the taking, making, circulation and possession with a view to distribution of any indecent photograph or pseudo-photograph of a child under 18, and these offences carry a maximum sentence of 10 years imprisonment. Section 160 of the Criminal Justice Act 1988 also makes the simple possession of indecent photographs or pseudo-photographs of children an offence and carries a maximum sentence of 5 years imprisonment. In addition, all published material is subject to the Obscene Publications Act 1959. Alongside this legislation, and in response to concerns about people downloading violent sexual material from the internet, Section 63 of the Criminal Justice and Immigration Act 2008 introduced a new offence making it illegal to possess extreme pornographic images. The offence is subject to a 3-year maximum prison sentence and targets a range of extreme material which is already an offence to publish or distribute under the Obscene Publications Act. The Online Safety Act 2023 created new offences for the sharing and threatening to share intimate images, including deepfake pornography, without consent. In this very bill, the government is also introducing new offences for the taking of intimate images without consent and the installation of equipment with intent to enable the taking of intimate images without consent. Additionally, human trafficking for the purpose of sexual exploitation is an existing offence under Section 2 and Section 3 of the Modern Slavery Act 2015. Section 3 of the Act extends to the commission of an offence under the Protection of the Children Act 1978, which covers indecent photographs of children, or Part 1 of the Sexual Offences Act 2003, which includes non-consensual offences of rape and assault by penetration. On the regulatory side, the Online Safety Act 2023 also provides additional protections by regulating user-to-user services that enable users to share content online. These services have duties to tackle illegal content, including child sexual exploitation or abuse, human trafficking, and extreme pornography offences. Under their illegal content safety duties, user-to-user services must put in place measures which mitigate and manage the risks identified in their illegal content risk assessment and implement safety by design measures to mitigate the broad spectrum of factors that enable illegal activity on their platforms. This includes the risk that their service is used to facilitate child sexual exploitation or abuse offences. These duties are now in force, and Ofcom has strong enforcement powers, including fines of up to £18 million or 10% of qualifying worldwide revenue. With this amendment, as I have set out, the existing criminal law already makes much of this content illegal, and the government are actively considering how this works in the online space and how best to ensure any gaps identified are filled. Turning to New Clause Amendment 7, and as I have just mentioned, the Online Safety Act 2023 creates a new regulatory framework that imposes legal duties on certain online service providers. These include duties to protect users from the most egregious content. For example, it gives online services that facilitate user-generated content duties to put in place systems and processes to protect users from such content where it is illegal. These duties apply to any provider that allows users to interact with each other or post content online as part of its service. In addition, the Online Safety Act also gives online providers that publish pornography on their own sites a specific new duty. This duty requires the providers of these services to prevent children from accessing it. My Honourable Friend's amendment is intended to also assign the illegal content duties in the Act there are for providers who host user-generated content to companies who publish pornography on their sites. Firstly, it is not necessary to do this to ensure that those providers are subject to the illegal safety duties for any user-generated content that they host. Where any pornography company that publishes its own content also has functionality for the sharing of user-generated content, then it will already be in scope of the Act's illegal content duties. It will also be subject to the other relevant duties in the Act that are for user-generated content, such as the duties to use age assurance to prevent children from the most harmful content, such as pornography or suicide content, if they are likely to access the site. Where a pornography company does not facilitate user-generated content on their service, then it would serve no purpose to give them these legal duties for this kind of content. The duties require providers to use proportionate systems and processes to protect users from content over which they do not have direct control because it is uploaded by users. As providers do have a control over which content they themselves upload, this type of duty isn't appropriate. Reflecting this position, pornography companies can straightforwardly be held criminally liable for content that they publish themselves, unlike user-generated content that they host on their service. If an online service provider commits an offence through the action of publishing its own content on its own site, then that entity can be held liable for breaking the law. Therefore, there is no need to apply additional regulatory duties for services for content that are already criminally liable for. Finally, turning to New Clause Amendment 51. Graphic strangulation pornography is illegal, but it is not always being treated as such and instead remains widely accessible on mainstream pornography platforms. There is increasing evidence, which Baroness Burton's independent review into pornography brought out, that choking is becoming a common part of real-life sexual encounters, despite the significant medical dangers associated with it. In response to the report, we committed to taking urgent action to ensure pornography platforms, law enforcement and prosecutors are taking all necessary steps to tackle this increasingly prevalent harm, and we stand by this commitment. The intention behind the Honourable Member's amendment is to extend the extreme pornography offence, Section 63 of the Criminal Justice and Immigration Act 2008, to capture depictions of non-fatal strangulation that amount to battery. It may be helpful if I very briefly explain some of the history and purpose of that offence here. The extreme pornography offence, which is one of possession, was created after a full public consultation. The offence targets possession of pornographic images, meaning particular categories of image produced solely or principally for the purpose of sexual arousal. These images need to be grossly offensive, disgusting, or otherwise obscene. It is very clear that the offence captures the possession of extreme pornographic material which depicts, in an explicit and realistic way, acts which threaten a person's life. Whilst it is always for the Crown Prosecution Service to decide whether on a case-by-case basis to prosecute the possession of extreme pornography, we believe that material depicting graphic strangulation is already covered by the offence. For example, such a video depicting someone with their hands around someone else's neck who is struggling to breathe may be captured by the existing offence, even if the result of the behaviour was non-fatal, because it is life-threatening. I also understand that the British Board of Film Classification would likely not pass for classification material that may depict less extreme acts of non-fatal strangulation for porn material accessed offline. As I have previously mentioned, the BBFC already regulates the distribution of pornography in physical form, for example, those old-school things known as DVDs. It will not classify material that is criminal or represents a credible harm risk. This generally includes pornographic content featuring strangulation, including depictions of throat grabbing, choking, gagging, and other plays on breath restriction, and also verbal references encouraging such practices. As I mentioned in relation to New Clause Amendment 7, the Online Safety Act 2023 places duties on relevant service providers to prevent and remove illegal content. Although dedicated porn provider sites do not have duties, they will be held criminally liable if they are found to host illegal content. This does not specifically include content under the Obscene Publications Act, but does include content caught by Section 63 of the Extreme Pornography Offence. Amending the extreme pornography offence as proposed by the Honourable Member would extend the offence to capture any strangulation that amounts to battery. I recognise that what the member is trying to achieve. However, there is a tension here that we need to be mindful of. I wholeheartedly agree that we need to tackle the radical proliferation of misogynistic and violent pornographic material online and the normalisation of strangulation in sex, particularly for young people. However, we must be clear that consensual strangulation between partners is legal, unless it results in serious harm. We therefore need to be mindful of what is legal in real life and whether depictions of that act are of such seriousness that it warrants interference with an individual's right to privately possess it. Furthermore, amending the offence in such a manner may cast unnecessary doubt on the scope of the existing offence by implying that strangulation must have otherwise fallen outside of it, and that the offence should therefore be interpreted in a very restrictive manner. However, I must stress that this is not to say action is not needed. Where the Government, in its consideration of Baroness Burton's report into pornography, finds there to be a need to legislate, we will do so. To summarise, it is absolutely right that we continue to adapt to the ever-changing harms online and improve its safety. I am incredibly grateful that these amendments have been tabled to give these important issues the debate that they rightly deserve in this place. However, all of these new clause amendments preempt the important but ongoing work by government to consider how best to respond to the suite of recommendations made by Baroness Burton's review. I would, however, like to reassure the committee that these ongoing considerations include how withdrawal of consent is aligned across offline and online material, the aims, priorities, resourcing and powers of the relevant regulators, and whether further legislation or regulation of the possession and dissemination of material depicting non-fatal strangulation is required. For the reasons I have set out previously, and given this government's commitment to take any necessary action following a full consideration of Baroness Burton's review, I would urge the honourable members to withdraw their amendments.
Shadow Minister, do you want to respond to that?
No,
Let me-
want to
Okay, so is everyone content for the new clause to be
Chair.
withdrawn?
With your permission, I beg to move that this committee be now adjourned.
Okay, the committee is adjourned and the sitting is coming back at 2 o'clock. Yes, so order, see you at 2. Thank you.
Committee Room 11, sound. Committee Room 11, sound.